3, 2, 1, start. That enforcement of the constitutional right and grant of redress embraces award of compensation as part of the legal consequences of its contravention. Stop. Award of compensation in a proceeding under Article 32 by the Supreme Court or by the High Court under Article 226 is a remedy available in public law, based on strict liability for contravention of fundamental rights to which the principle of sovereign immunity does not apply, even though it may be available as a defense in private law in an action based on tort. Stop. A claim in public law for compensation for contravention of human rights and fundamental freedoms, the protection of which is guaranteed in a constitution, is an acknowledged on strict liability made by resorting to a constitutional remedy provided for the enforcement of a fundamental right is distinct from, and in addition to, the remedy in private law for damages for the tort resulting from the contravention of the fundamental right. Stop. The defense of sovereign immunity being inapplicable, and alien to the concept of guarantee of fundamental rights, there can be no question of such a defense being available in the constitutional remedy. Stop. It is this principle which justifies award of monetary compensation for contravention of fundamental rights guaranteed by the Constitution, when that is the only practicable mode of redress available for the contravention made by the state or its servants in the purported exercise of their powers, and enforcement of the fundamental right is claimed by resort to the remedy in public law under the Constitution by recourse to Articles 32 and 226, for contravention of fundamental rights. Stop. Certain further observations in Rudul Saha which may tend to minimize the effect of the principle indicated therein, do not really detract from that principle. Stop. This is how the decisions of the Supreme Court in Rudul Saha and others in that line have to be understood, and Kosturilal distinguished therefrom. Stop. Para. Mr. Ghoshal, learned senior advocate appearing for the state respondents, submits that the arguments advanced by Mr. Chakraborty do not stand supported through appropriate pleadings in the writ application. Stop. Para. He further submits that the petitioner has lost his right to avail compensation, having not preferred any appeal against the judgment delivered on 18th April, 2008, wherein the learned court did not issue any direction upon the accused person to pay by way of compensation to any person for any loss or injury caused by the offence. Stop. Para. According to Mr. Ghoshal, regarding compensation as per the new amended section 357A of CRPC, the recommendation of the learned trial court was required, and only in the event of such recommendation, the matter is required to be placed before the District Legal Services Authority for deciding the quantum of compensation, and that for non-impediment of the District Legal Services Authority, the writ application is liable to be dismissed on the ground of non-joinder of necessary party. Stop. Para. He further submits that the petitioner's son was not the sole bread earner of the family, and the compensation as paid in the writ application is totally absurd, and the writ court cannot calculate the actual amount of loss suffered by the petitioner, and that in terms of the provisions of the said scheme, the petitioner ought to have approached the District Legal Services Authority. Stop. The petitioner is not entitled to any compensation since he had not approached the appropriate authority under the said scheme. Stop para. According to Mr. Ghoshal, the judgments delivered in the case of Lilavati Behera within bracket Supra, Kostudilal within bracket Supra, DK Basu within bracket Supra have got no applicability in the instant case since the said judgments were delivered in the backdrop of custodial death. Stop para. In reply, Mr. Chakraborty submits that the petitioner seeks relief of mandatory compensation as exemplary damages in the instant application under Article 226 of the Constitution for established infringement of fundamental right under Article 21 of the Constitution of India, being a remedy available in public law. Stop para. He further submits that the writ application has been preferred admittedly prior to promulgation of the said scheme and prior to the insertion of section 357A in CRPC, vide notification dated 30th December, 2009. Stop. The said amendment was brought about by the Code of Criminal Procedure, within bracket Amendment Act, bracket close, 2008, with effect from 31st December, 2009, vide notification dated 30th December, 2009, and almost 3 years thereafter, in exercise of power conferred by section 357A of CRPC, that West Bengal Victim Compensation Scheme for providing compensation was framed and notified vide notification dated 1st November, 2012, and in the backdrop of the facts pertaining to amendment of CRPC, and promulgation of the said scheme, question of relegation of the matter to the District Legal Services Authority does not occasion. Stop.